Navigator page, and all of you who have registered and attend today will receive an email as a follow-up with the recording and a link to the materials. So we do expect to have questions. In fact, we encourage you to think of questions as we go through the session. Please feel free to post those at any time in the chat box at the bottom. A reminder that any questions and anything that you put in the chat will be seen by all participants. And now it's my pleasure to turn it over to Professor Kaloran. Thank you.
Hi, everybody, and welcome. We are pleased to have you here today. I'm Nicole Kaloran. I'm one of the professors with the Vermont Law School Entrepreneurship Legal Lab here at Vermont Law School. I am happy to have today two of our students and Grammy nominee artists, as well as our own Professor Goodenough, to present on intellectual property, some of the opportunities and the barriers and challenges that face minority communities and marginalized communities. So I will be emceeing. I'm going to, we have a slideshow here that we can share with everyone after the presentation. I'm going to go ahead and hand it off to Verse, who is our artist that's joining us today, to give a little bit of a background on him and his experience and how he has navigated the world of intellectual property. So Verse, please take it away.
Yes, how are y'all? How's everybody doing today? My name is Verse. I got invited here through one of my close friends, Robert Baker. I really appreciate everybody's time. So pretty much I have my own like small business named Verse Management. And when I was in college, I met Robert Baker and one of my other close friends, Steve Asandu. And I was always like the networker, the manager type, trying to make sure my friends are okay. Then Steve Asandu was more Chichi, which is more of a, he's a producer. And then Robert said, I'm gonna study law. So we've had a plan for about 5 years that this is what we wanted to do, and was able to bring it to fruition. So pretty much I started my company because I wanted to protect artists, songwriters, and musicians in their career. So that's the power of, like, we have a triangle offense that I'm gonna be the manager, Chi-Chi's gonna be the producer, and Robert is gonna be the lawyer. And that's how we all came together. Could go to the next slide. All right. So a little bit about my client, just so y'all can have an understanding of what type of magnitude I'm dealing with. Chi-Chi has over 1 billion plus streams. We was actually just nominated for 2 Grammys. We went out there to Las Vegas a couple weeks ago. He's triple platinum, double platinum. That's just like over 500,000 sales, 1 million sales. When you go platinum, he's been on Billboard. I don't know if y'all familiar with Lil Baby, Gunna, 42 Doug, Lil Durk, Young Thug, Travis Scott, Meg Thee Stallion, and her. But those are the type of clients that we are working with on a daily basis. And they actually signed one of the biggest publishing deal with Universal Music Publishing Group last year, which we're very ecstatic for. So what is my life as a manager? I feel like my main life as a manager is to protect my clients and to make sure that they are being compensated on everything they're doing. So facilitating, making sure they're introducing to the right people, connecting them with people who's going to take their career to the next level, protecting them from people who could be misusing them. I'll oversee agreements. I'm scheduling, I'm participating in studio sessions. I'm seeking collabs with other producers and artists. I'm making sure video shoots are getting done. And I look at my job as not a 9-to-5 job, but more of a 24/7 lifestyle. I may get a call at 8 p.m. I may get a call at 3 in the morning. And that's the opportunity and responsibility I take as being a manager, is making sure anytime that they're working, that I'm protecting them. And that leads to why copyrights are very important. So what is intellectual property to me? So to me, intellectual property is the ownership of your creative ideas. So protecting your music against use by others. So if there is no copyright, there is no life of an artist. There is no money being created. People are licensing your music so that they could use it. So creativity, hard work, and craft is just something I preach. So anything could be copyrighted in a tangible form of medium. So recordings, merchandise, logos, a journal. Once you create a physical form of it, it's technically your copyright. Go to the next one. So intellectual property that matters most to me. So copyrights, which is creative works in tangible forms. I'm not sure all y'all know this. Trade secrets, operations kept from general knowledge, and trademarks, which is brand identity. For example, I manage a country artist. If he does a guitar to like one of Chris Stapleton's songs, but does it in his own way, that's a form of a copyright. So original music is intellectual property. And then I also have a production company and clothing company called Catastrophe, and we have logos. So pretty much my lawyer was able to go to the copyrights departments and register our work to make sure we're okay and make sure that no one's stealing our ideas.
Excellent. I think we're going to switch now over to Professor Goodenough, who's going to give us a brief overview of the different types of intellectual property. So Professor Goodenough, if you could jump in here.
Yes, thank you so much. As Verse has laid out very, very clearly, if you are going to be a creative artist, you need to be able to defend and protect your work, and that defense and protection gives you a chance to monetize it. Not like you are creating value for yourself or for your clients when that kind of intellectual property is possible. It's also important to play defense as well, by the way. If that's offense, defense is where you are avoiding infringement. While you clearly want to protect your own work, you also want to make sure that you're not infringing on the work of others. There are some concepts like fair use, which allow you to make some use of the work of others, but you want to be aware of what you're doing and get licenses in return where you need them. There are 5 principal topics and types for intellectual property that we're going to be taking a quick look at today. Copyright, patent, trademark, the rights of privacy and publicity, and trade secret. And we're going to take each of those in order and also have a bit of a commentary on them from our panel as we go forward in each of these cases about how, once we've established some of the basics about how that works with minority communities, how folks can access it, what are the problems and difficulties that may arise. So if we have next slide. For instance, for marginalized communities, there's a set of challenges. One of them is the need to have capital, to establish your rights, to defend them. It's the lawyers, you heard from Verse, lawyers are actually useful in this context, and sadly they generally want to be paid something. So again, we need capital to both develop the work and to figure out how to defend it. Need knowledge to deploy. And also, the creativity model needs to be one where we understand the possibilities of protecting our own work. Many communities have a more sharing attuned approach where they are. Creativity is something you share rather than something you own and protect, and that's perfectly fine model. But it is a model that as Verse said, that you don't necessarily make a living at, sadly. So I would throw it open for just a couple minutes to commentary from our rest of our panel on some of those initial thoughts. Anyone wanting to jump in and comment on any of those topics before we turn to the individual types of intellectual property. If not hearing, we'll pick up the commentary as we go forward. Then next slide, Nicole. This is copyright basics. And copyright is our starting point. Copyright is a set of laws that apply to works of authorship that are fixed in a tangible medium of expression. You heard those words from Verse earlier. Those are the key points in the copyright law that say what they can protect. So it's things like texts. I'm sorry, I have a typo there. Text, video, music, artworks, even dance and architecture, creative works like this are what it applies to. It can even apply actually to some extent to software, to technical writing, to other pieces. It doesn't have to have great artistic merit, but it does have to have creativity and originality to go forward. If you're the right kind of work, the rights that can be claimed include making and selling copies, classic book publishing, copies of records, copies of the music itself. copies of videos. It also includes the performance of work. So performance of music in live performances. It covers the display of works. It covers the performance of a video when a video is run. That's a performance. It also covers derivative works. That's the ability to make a work based on something that takes a lot of the underlying creativity. So a subsequent novel in a series or a film of a novel, those would be derivative works. Now, we often license those. Sometimes the author or the creator undertakes the distribution themselves, but more frequently we are in a world of licensing, and this is where people in the business like Verse come in, which is to help manage that. He spoke about that record licensing deal that he was able to do, and that was a matter of finding a big company that wants to undertake some of the distribution of the work of the artist. Again, something that depends on the ability of copyright to exist and the ability of people to know how to protect themselves. There are exceptions, which include fair use, the ability to make fair quotations, fair references to things. That's a deep subject we're not going to go into much at the moment. Just be aware it's there. And the process on this is all quite easy. The copyright is given the minute an eligible piece of creativity is created. And while there is a notice and registration provision that can help, it is not fundamental to the protection. So it is very easily created. And if you want more information, the Copyright Office of the government is a good source, and its web link is there. Nicole, go ahead, Robert. Go ahead.
You can stay right there, Professor Cullen. But if I might add, for some of you, when you think of copyright, an image comes to your mind. For instance, a symbol of a C with a circle. But what doesn't come to mind is, which we'll get into even more, and what was expressed earlier by Verse, was the fact that the symbol wields power. A legal right to its owner to do what they see fit with their work. Yes, copyright laws is applicable to many different works of authorship that are fixed in a tangible medium. But however, what is most important is the monopoly that this area of law provides to its owner and the protection it affords in the many categories that that were expressed in the previous slide. And I'll let Professor Goodenough to continue as he gets into the rights itself.
Robert and Verse, if you actually want to pick up here, because I think that gives enough of a background for folks to understand. Robert, your comment, I thought, was very, very perceptive and telling, which is the symbol actually is a symbol of power. It gives people economic power. It gives people control over their own work and what happens to it, which is not just economic. It also gives you control over where and how it's going to appear. Do you want to comment on that a little further, either Robert or Verse?
I'll let Verse go first if he would like to, but if not, I'll take up.
You can go, Robert.
Well, again, like the slide itself is saying, the author is the creator of the original work. That's what Verse explained earlier with the producers and the artists he works with, and and Professor Goodenough spoke to them being a composer or a performer. But the rights that Professor Goodenough was speaking to were the rights to reproduce, transfer, perform, or display, and the right to make new creative works based on an original underlying work. And with those provisions are statutory provisions. Those copyright law itself creates a statutory protection. And we didn't highlight it in the previous slide, which I think we'll go into fair use in a second, Professor Goodenough, is that correct? Oh, you're muted.
We can, if you'd like. It is fair use is this exception which is there for making quotations and all. This is often used in music like rap and hip hop, where there's often quotations and clips from prior work that is there. The ability to do that is there, but it is a limited ability to do, and it can be used for commentary and that kind of thing. So again, it's one of those areas where getting some advice if you're wanting to rely on that exception is not a bad idea. But Nicole is I think the next slide also on copyright is, or do we move?
Next slide was on patent basics. So
Okay, then we'll finish off here. Verse,
Yeah.
Okay.
would you want to comment? Because one of the things that strikes me about copyright is because it has relatively low barriers to entry, relatively inexpensive to claim these rights, that these have been a set of rights that folks from the Black and other communities have been able to move into with some success. Would that be a fair observation in your view?
Yes, sir. I would like to bring up, so not only the power of copyrights. So if I use somebody else's work and I'm making money off their work, I actually got on the phone with the lawyer who did the Marvin Gaye. His name is Michael in the Robin Thicke. Like, I know him personally. I work with him because I manage another client. And they had to pay the Marvin Gaye family $5 million because they literally just used the phrase in the song. But that would not be able to be compensated unless they were protected. So not only does copyrights protect you and your work, it helps people not steal it. And if they do, oh, we getting paid. And that's the thing I want people to understand, is that copyrights give you the freedom to do what you want. With no copyrights, there's no freedom, there's no life, there's no money, there's no licensing.
And as Verse mentioned, and as Professor Goodenough mentioned, that once you create it, it's yours. Once you've created it and put it in a tangible medium, but it's taking the extra step of registering it. There's power in that. It's a presumption of validity, and it's a statutory right to control. Specifically, like if someone infringes, it creates an automatic cause of action for you, and it serves as a little bit of a oomph, I would say, in terms of litigation, because again, it's a presumption of validity as long as it's registered, and that is the strongest element in one's case. And when they bring a cause of action regarding infringement itself.
Robert, that's actually a very good point, and it does emphasize that even though you do get the automatic protection at some level, that registration process can help. Registration is difficult in this. Again, it takes a little time. You have to get in touch with the Copyright Office through that website. They walk you through the procedures. There is some filing fees. It's not terribly expensive. It is something that most people can manage once they get a little explanation and a little practice at it. So it is not a huge barrier, but it's a little bit of a barrier, but it's one that is worth doing to get that extra piece of protection. Why don't we move on then to patent, and we can come back around to some of these copyright questions a little bit, but I think we've cleared that up, hopefully.
Sure. I just wanted to note too that with Verse's example, it's not only individuals, it's their families and future generations that might be able to benefit from copyright and the wealth that passes. So I think that can be a useful tool to address the wealth and gap and between generations, and to try to build up wealth in future generations where it hasn't been. So next up we have patents, and I'll let you take that, Professor Goodenough, and then we would love to hear from Chianna Hart, who has some scholarship on this topic.
Yes, if you don't mind me starting off on this again with some basics. If copyright applied to basically creative works and works of authorship, that end of things, the patent system applies to inventions. The categories that are in the statute include machines, manufactures, compositions of matter, and methods and processes. These are pretty broad categories that govern, again, most of the kinds of things that would be considered to be inventions in common discussion. As with copyright, once someone gets these rights, they are often licensed or transferred. In today's scientific and technical world, sometimes it's quite hard for an individual to develop and market patentable items. So licensing is important. And also frequently it comes up in the context of being employed, where the employer will seek to have the patent. Making sure that people have decent terms for that transfer is important, so that they don't just hand everything over to an employer without getting something back in return. Patents won't apply to laws of nature or naturally occurring substances. So Einstein's equals MC squared, really good discovery, doesn't get patentable. It has to be altered in some fashion to be patentable. The invention, the qualifications here for the invention under the patent law are that it has to be novel, which means not previously made public in some way. I'll come back to that in just a moment. It has to be useful, which is typically pretty easy to do because we're not going to worry about patenting if it's not useful. And then non-obvious. It isn't something that a skilled person would easily do as a next step. It has to have a real inventive element in it of some kind. So to go back on the not previously made public, there's a little exception here. People who are the inventor, if the inventor makes it public, the inventor gets basically a year's kind of grace period to go, oh yeah, I've got a file. And but it's important. One of the important things about patent is to move quickly. If an inventor has something that is going to be patentable, it needs to be in a circumstance where they move quickly to do that registration. And that registration is important because unlike copyright, where do-it-yourself is probably a possibility for any registration in copyright, the patent process is quite involved. The patent applications are tricky, they're difficult, they're technical. Yes, individuals can do them and do them, but it's also a place where professional help is thought to be very, very useful by most people. Unfortunately, that professional help can be expensive. A very standard patent is going to cost probably $10,000–$20,000 to get. Anything more complex can be more expensive. I was talking with an inventor this morning, actually, who said that they had spent they and their institutional sponsors had spent $250,000 on the patent process. Ended up getting a very good result, but that kind of spending can be a barrier. The process leads eventually to registration, but that registration will be subject to some negotiation to make sure the patent people will examine the patent and make sure that it is meeting the requirements for all that we set out above. Their approval then finally grants the patent. And patent rights run, by the way, for 20 years from application in most circumstances, and give you the right to, as the same way that we had the right in the copyright to limit who can use or whatever. The patent a patent holder gets very broad rights in limiting the manufacture and use of the invention. And more detail is available there at the U.S. Patent and Trademark Office, where their website is listed. Helen, do you want to take give some commentary on some of that?
Yes. Hi, can you hear me?
Yes.
Okay, so I had the pleasure of doing my advanced writing requirement on this topic. I didn't want to talk about intellectual property in general because I felt like copyright and trademark was something that has become a little more easily accessible to marginalized communities, but it was patent that I found was lacking. And so I did my research, and what I found was that women, people of color, and lower income individuals patent inventions at significantly lower rates than like their white male and wealthier counterparts, and that African Americans patent at even lower rates than women. So I thought to myself, why is this if patents are awarded without regard to race or gender or income? And we can move to the next slide. So on the USPTO website that Professor Goodenough talked about previously, this is their life cycle. Looking at this, it seems like the patent system is just simple. You learn about the patents, you prepare the application, you file the application and pay the fees. Then there's the examination process, and then that's it. But there's so much more into this. Like Professor Goodenough just talked about the fees, like someone spent $250,000. So we can expect the individuals from these marginalized communities to be able to afford that. But also, if they have these inventions that they created, they should have the same opportunity to be able to patent it. So I wanted to research this topic to see how to gain information, gather information to bring back to my community, to see how people can patent their ideas, their inventions, so that other people don't steal it because they can't afford to patent it. And we can go to the next slide. So as I talked about, that process we saw with the 5 arrows seems very simple, but it's very complex. And this is why I felt like researching and writing a 25-page paper on this was necessary, because I myself didn't know about this process. I took classes such as corporations to learn the language. I took classes such as intellectual property. I took securities and regulations. It was a struggle for me because it was a language barrier. This is my first time even hearing about these things. But then Professor Variety told me Investopedia. Go to Investopedia. It has like all the words defined out for you so that you can be able to navigate this system. So that's just a little tip I threw in there for you guys. If there's a word that you just don't understand, Investopedia is a great site. Okay, next slide. So these are the factors that I found that contributed the most to the challenges and barriers. The first issue I found, which I also struggled with, was the low level of awareness of just the patent system in general. A lot of people, you can ask them about copyright, trademark, they may know about it. But as far as like the patent, they don't know. And you know, these small businesses could be creating new processes, could be creating new methods, and they're not. They're not really creating generational wealth that could come from that because they don't know how to navigate the system. So I think we need to increase awareness of the patent system and the IP rights that come with it. Help people decide whether their invention is patentable because you don't know if you just don't know. And I thought exposure was so important, but I think exposure needs to happen early on with our youth. We need more educational programs after school or community-based programs that center around STEM, the science, technology, engineering, and mathematics, so that when they grow up, they could patent. They already have a basic knowledge about the patent system. And if they were to come across an invention that they created, they already have an idea, they heard of it. They don't have to be like me, who, you know, you get into law school and you take these classes and this is your first time really getting that basic knowledge and understanding about it. Also, lack of resources. What I found was that when you have someone represent you who understands your barriers, sometimes it can be easier to help people navigate through it. And I think less than like 2% of African-American attorneys were intellectual property attorneys. So I said we need to find a way to increase that. Also, this help entrepreneurs and startups monetize their invention and business. And as I stated before, early exposure is very important. And lastly, capital is so important. Like Professor Goodenough said, we have to pay for these attorneys. And then the patent fees, we have to pay for that as well. So also trying to do it on your own is very complex. It can be confusing, you know, it can be mentally draining, and people will just give up. So I think it's important that we have like grant programs just to kind of alleviate some of these barriers and challenges that are already there. Like, you know, let's get some capital to these marginalized communities. Next slide. So what I found, this was a personal challenge for me doing my research, was the lack of data that's out there. I mean, there is some that is out there, and it does indicate that women and minorities basically are underrepresented as inventors. But what I found funny was that the USPTO, they collect information. They'll get your name, your residence, your mailing address, but we don't know whether this is a minority or not. Like, we need this demographic information, but there is also a concern about getting that information. They do have the IDA Act that would be on a voluntary basis, because we don't want people being discriminated against for filing a patent application. So if they do give their race or anything, we don't want them not to be approved because of that, because we do know that discrimination does happen. So I'm still trying to figure out how can we get more data so that we can know how to address the problem accurately. Next slide. So I thought this was a great quote, because I'm the type of person that I don't really like to talk about the problem too much. I want to see what are our solutions. So I thought this was great. Next slide. So some of the opportunities that I came across was that the USPTO and the SBA have ongoing programs to help meet the needs of our potential inventors, entrepreneurs. Access to finance. The USPTO offers discounted fees to individuals and small firms to maintain like a number of targeted programs, such as like the pro bono program, law school clinic program, and the pro sale assistant program. Next slide. So I know that the solution is not simple. I think this is a problem that we need to help. It's very essential to help the marginalized community navigate intellectual property and to create opportunities to help increase the awareness, to help bring more resources and access to capital so that we can have more people from these communities patent their inventions and not risk other people stealing their creations. And that is it. Thank you.
Excellent. Thank you so much, Chianna. That was wonderful. I want to open up and there's a couple of questions. I don't know if Professor Verratti is going to be able to stick around for this, but he had a question, but I wanted to see first if there's anybody who has any questions about patents from the audience to follow up on Chianna's presentation. Go ahead, Professor Goodenough.
I just was going to add that to reiterate what the mention of there are some avenues for help. Folks should be aware that a number of law firms that specialize in this area do offer some pro bono help. Qualifying for that can be a little hard, but it could be worth looking into. The government programs that were mentioned would be good as well. And we should also mention that our own Navigator program has possibilities for some education and perhaps even for some assistance with legal fees in certain circumstances. So people should think about following back up if that is of interest.
Yes, thank you. There was a question from Ben Verratti in the chat, who is the same Professor Verratti that Chianna mentioned. He says, from a licensing perspective, I'm curious whether folks on the panel might have thoughts about how lawyers and consumers can apply more pressure on digital performing rights organizations like Sound Exchange to pay artists more fairly. I've represented musical and film artists in New Orleans for years, and this was a common source of frustration. So just wanted to open that question up.
That sounds like a question for Robert and Verse.
Yeah.
What's crazy is I actually is where I'm.
I'll let Verse go. Go ahead, Verse.
You hear me?
Yeah.
Yes.
So I'm working with actually Sound Exchange right now, and the beauty of copyrights and what actually makes it complicated is that there's a lot of forms of digital royalties, and there's a lot of forms of how you get paid. And Sound Exchange has to deal with digital radio, so non-interactive streaming. So pretty much playing music that I can't control, the Pandoras, the iHeartRadios, the Amazon Music. So it's like Sound Exchange is one of the biggest performance right royalty payout, and I'm actually frustrated with them as well in a way because it's been a pain to get paid in the music industry. They make it very hard to collect your money. So the frustration, I don't know if I'm answering the question or not. I'm trying to read it.
How can lawyers and consumers apply more pressure on digital performing rights organizations like Sound Exchange? What can we do?
Well, I feel like it's power in numbers. So we must come together. Like when I was having trouble with this, I called a manager. I was like, bro, how do I get the Sound Exchange? He was like, oh, I have a contact. I have a former contact for it. I was like, I asked one of my friends, how do I talk to Sound Exchange? So luckily I knew someone who knew the head of the company. So pretty much when I'm dealing with problems, right, I try to find the person that could get me to the head of the snake. I don't want to deal with too many middlemen because nothing can be changed. So I got in contact with Sound Exchange and I submitted our LODs. And actually a Sound Exchange is part of the producer agreements in the contracts. So they put that LOD is like a repertoire chart of like the percentages who each person is getting. And then the lawyer must sign off on it and make sure everything's okay. So if the lawyer puts one wrong word, one wrong number, it has to be literally identical. And that's where I learned that we have to, like, the lawyers have to step up their game and make sure that everything is protected. And then the managers like me must come together to put pressure on Sound Exchange and make sure everything is correct, if that makes sense. So building a community.
I would just add and say that Verse is exactly right. I think that it's all about who you know. And until this problem becomes more mainstream for the public to where it places pressure on people like BMI, ASCAP, Sound Exchange themselves to actually put in place measures to facilitate a faster payout, then you'll still have to resort to, it's all about who you know, and, getting their attention and letting them know it's affecting you and the hardship it may be creating.
Those are great answers. I suspect that both Verse and Robert would be open to following up offline with our professor in that context to get further information on that.
Yeah, and he had to take off, but he left a great comment. In my practice, I found the key determinant of small business and entertainment success was rarely creative ability or a great product or invention, but a readiness to take the necessary steps to structure their business operations in order to get paid now and again and in the future.
Well, I think talent was probably a piece of it, but talent is not
right.
enough.
Talent is not enough.
And talent is not enough. You've got to build these kinds of protections on top.
Yes.
Can we move on? There's all kinds of great stuff, but I do want to make sure
Yep.
we get through. Trademark basics, another category of intellectual property. I hope that if you haven't been aware of it before, that you're getting the picture that intellectual property has these different buckets, and you need to know what bucket you're in to get the right legal protection and know where you are. This bucket is trademark, and trademark applies to designations of origin of goods and services. Where are your goods and services coming from? What companies, what individuals? And it is typically words or designs that identify the maker. The classic one, of course, is Coca-Cola with its script. The design is its script approach to the words, and the words Coca-Cola are registered trademarks and are very, very strongly protected. There's often some licensing in this, although less so, because trademarks are often done by the company that wants to be the one to use them. There is a state system, which can be somewhat important, but the really important system is the federal system. And in the federal system, you can get some protection simply through use, and then often putting the little indication TM next to it. That just is an indicator, hey, my company is claiming this slogan, this name, this image as a trademark. And then you get much more protection, as you were seeing in the pattern, through registration. And federal registration allows you to put the R in the circle or the S in the circle if it's a service mark next to the mark, and say, hey, everybody, we are registered with the federal government, and use this at your peril. Now, in order to get that registration or even any use at all, the mark has to be distinctive. It has to be something that is people will look at and go, oh, that's the Coca-Cola company, rather than something that was just more generic. Soda pop, you could not trademark soda pop. Well, why? Because that's a generic, and a generic gets no protection. And also, your chosen one can't be too close to other people's chosen ones, because there can't be a likelihood of confusion. It has to be distinctive. Finding out whether or not there are other things out there is a good piece of homework that people need to do. That you can go to the Patent and Trademark Registry at the website listed there. They have a registry you can go check and see what's been used, what's available. You can also do simple things like have a Google search or look at whether the URL, the web names have been taken around it. If you decide to go forward with registration, it's a moderately complex process. This is not as complex as getting a patent, but it's certainly more complex than the copyright. So it's, again, do it yourself as possible, but you need to approach it with some caution. There are some of the online legal advice services like LegalZoom that will walk you through the process. Again, probably not as competently as a lawyer would, but on the other hand, perhaps less expensively than the lawyer would be. So again, this is an area where some assistance is probably a good idea.
Excellent. Yeah. Next up, we had some thoughts from Verse on trademark, because this is another piece that you mentioned that helps protect your music and your income.
Right. So I was just piggybacking off on what y'all was saying. You could register your logo and your band name with the U.S. Patent and Trademark Office. And musicians, like, to keep it kind of specified, musicians typically register their trademarks under one or more of the following clauses. And I've actually used all of these clauses. Class 9, which is audio and video recordings. Class 16, for things that are printed, such as posters, stickers, songbooks, album covers. Class 25 for clothing and merchandise, and Class 41 for entertainment services, online video recording. So, it gets very complicated.
Oh, sorry.
No, I was just saying, yeah, it could get complicated. So with wonderful people like y'all, we could figure out a solution.
It is a bit complicated, including, as you were rightly pointing out, which class is chosen, because that's critical. That's one of those things you get down in the weeds in the registration. You say, what class should I be doing? And that matters, because that, when you say, you could imagine doing things like, oh, I'm audio and video, but the printed stuff and the clothing, you wouldn't necessarily occur to you that the artists have also the potentiality for earning in these other categories. So again, experienced help is quite useful in this context, because it can be a bit complex and all. Let's move on then, if we could, to the privacy and publicity. This is a set of rights that apply, another bucket, a set of rights that apply to an individual's name, likeness, and often their voice, and their voice quality, the identifying characteristics of individual people. This one is state by state law. There isn't a big federal statute on this. There, you get some protection under the trademark laws, but basically this is state law, and it's the state where the individual is domiciled, where their home base is. It prevents unauthorized commercial use, like advertising or the sale of the image, creating T-shirts or things like that, using their image either for some kind of endorsement or as a marketable thing itself. So for celebrities and celebrity artists, this is a very important right to make sure is understood and protected going forward. And by the way, you don't have to register to get this right. Yeah, you getting born with your own face is where you start with this right. So, but you do have to be aware of it and have a plan for using it. By the way, this does not prevent factual uses, news uses, reviews, that kind of thing. There's a broad swath of uses that are open to the public in reporting or doing a magazine story or something like that on a celebrity or on the rest of us, for that matter. It can be licensed, as with all these other things, and there's no registration. There's not a central office for this, so the reference we've given you is to a Wikipedia article on it. If you hand off, Versh, do you have, any of the rest of you have a comment on that? Quick comment.
Right, that's a good point.
I think you really covered it, Professor. I think you covered it well.
Okay, thank you. Again, it is if you're representing or are a creative artist, any kind of celebrity or where your persona has some value, this is really important to pay attention to. Let me then move on to the I think the last of our buckets, which is trade secrets. And trade secrets is the law that applies to financially valuable secrets. These can be technical secrets, processes, data, customer lists. It was interesting to hear Verse talk about, the underlying methods of their business, things that are the secrets, part of the secret sauce of your business, but don't fall into something that be copyrighted or you choose not to patent or it couldn't be patented, all that kind of things. The protection that this area offers is limited. It does, unlike patent or copyright or trademark, where essentially you get a right in the thing itself. Here, it really only applies to improper takings or spying. Other people can reverse engineer or have an independent discovery. All of that is possible. There's no protection in the underlying information, knowledge, or method. But what it does do is it says that people can't steal your things. Again, the classic Coca-Cola recipe is a classic example of a trade secret. They never patented it. They've kept it secret. Among other things, by the way, if they patented it, their patent coverage would have run out years and years and years ago. By keeping it secret this way, they can deal. And the owner must take reasonable steps to keep it secret. In order to receive this protection, you have to actually work to keep it secret. Things like locked files, password protection on your computer files, And often a network of confidentiality agreements and NDAs, people agreeing that they're going to keep this secret when you tell it to them. Being asked to sign all these NDAs, what happens in the modern world, can be a little annoying, but it is people often trying to make sure they've got their web of agreements in place to help keep their trade secrets. No registration. This again is one of those things that's just either you got it through your steps you've taken or you don't. And again, there's a Wikipedia reference. Verse, you had made a mention, I think, of trade secrets as being potentially important for your clients. So do you see this as a narrow thing or a more broad thing? How do you counter that?
I mean, I feel like it's very important because, you know, we have functions and a foundation of how our business is supposed to be performed. And if that information gets out to certain people, then it compromises my whole business. And that's the main thing to understand there is protecting not only myself, but the people who I'm running the business with.
Great. Yeah. So it can be an important element in creativity. It can be an important element in many kinds of businesses. Again, almost every business has a customer list of some kind that they would just as soon not have be public, and have just as soon people weren't able to de-encrypt and use if they could break in on it. Chianna or Robert, do either of you have a comment on the trade secret protection?
So this made me think about non-compete clauses. Like, what about the employees that's working for you and then they quit? Like, those type of clauses in the contracts will help them, like, for so many years, maybe 2 years, not to really compete in that area. That's also something that comes to mind with trade secrets is, what about the employees who's worked so closely to this company, and then after they leave, you know, maybe they're trying to take the secret and, you know, make it a little different, still in the same area. So I just think those are also important, as well as non-disclosure agreements to protect your business. There's many avenues.
No, that's an
Yeah.
important addition. Thank you for that.
And,
Robert?
and specifically when I think of it as it relates to verse management, you know, the artists, the producers, the beats they're making, and the artists that they're working with, NDAs come into effect where it will restrict them specifically from using that beat or that sample that's contractually designated for a particular artist with from using it with another artist, and even non-competes, whether they're in a process or they collab with two verse management producers on a particular beat, and they, for some reason, decide not to move forward with the company. You can't then use that product that was made under the supervision, under the guise of verse management, when you move on to your own personal or endeavors. So that's specifically where I think it plays a major role with the music industry.
Yeah, so both of those points are important, that we can use contracts to construct additional protections, whether it's through a confidentiality and a non-disclosure approach or through some kind of non-compete approach. It also reveals a little bit of tension here, because there's some tension between the companies, which are looking to create and maintain value, and the employees who are trying to maybe make a living. And depending where you are in that power structure of one person's cool agreement, maybe another person's, oh dear, why did I sign that agreement? So it is an interesting dynamic as to where you are, whether you're the employee or the company, as to where you come down on some of these issues. But the important thing I think that you're hopefully taking away is that it's very important that you understand the basics of this, and then understand how to get some help around it in the more complex ways that Chianna and Robert are both talking about. What's our next slide, if any? Do we have?
Well, next we had an example that Verse provided, and then some sort of future steps in what they're doing in the future and what they're working on now.
Great. Verse, and Robert, if you don't mind picking it back up.
Yeah, so this is just an operating agreement between my company, just showing the importance, like my lawyer drew all this up, the importance of the technicalities and the specifics of each word. If one word is wrong, if one letter is wrong, it could come back on us. So that's my main thing, is to show, like, I mean, this is very important information. So it shows how I get paid.
Essentially, yes. And also, just, you know, for people that are not very aware how many pages it might require and the specificity that one must use in terms of words. So won't keep it up too long though.
Yeah. And then we had, what are you working on now?
Oh man, so I'm still a substitute teacher in Atlanta. This is just like a gem I've learned. Like, so my dad is a educator. He's been a teacher for 30 years. So I'm a substitute in DeKalb County, K through 12. So what I do is I go through the schools in my community and then I spread my brand. How can I spread my brand? Okay, I go to the youth. And that goes back to what you were saying, Ms. Hart, about having youth programs in our community for not only minorities, even majorities or everybody don't have this type of knowledge. So if this specific knowledge is applied and put out in our communities, this is going to make trademarking and copyright a whole nother understanding that we need. So me just bettering myself as a manager, learning copyrights, continuing, because there's always something new you can learn every day. You know, marketing my music, building relationships. And like, I want to win a Grammy. Like, we got nominated, we lost, but you know, I want to continue to help others and protect their music.
Nice.
Oh yeah, and Robert, we waiting on Robert to graduate.
That's right.
I have a lot of work for him and anybody else who's interested.
That's right up there at the top. I love wait for Robert to graduate. And then some concluding thoughts from our panel, and we'll take questions too. We don't have any more in the chat, but please round us out.
I'll finish off too. I know I wanted to add that not only is the importance of copyright is for the author and the owner, but it's also for the consumers, like we was going back. The consumers can't enjoy material unless it's copyrighted. I can't go on Apple Music and go stream my favorite song, which is Phil Collins' In the Air Tonight, without it being protected. I'm enjoying the boom, 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 boom. That's a copyright. Nobody could go make that without letting Phil Collins know, hey, I use this. So that's my thing. And I want to end with a quote, actually from Mark Twain. And then I don't necessarily agree, but I think it just goes with the complexity of copyrights. And he says, only one thing is impossible for God, and that is to find any sense in any copyright law on the planet. So that just shows you that this is a very diverse subject. And I'm really appreciative that there are individuals constantly working on this matter to better it. And this is very, like, any questions, any way I can add advice or help, I'm all for y'all. So I really appreciate your time.
Thank you so much. First, any final thoughts from Robert or Chianna?
No final thoughts for me. I think we've done a great job of, laying the groundwork, so to speak, and introducing this idea to the community. I will just add that, if there's any questions that one might have for myself or Verse, and I'm sure all of the panelists today, feel free to reach out to Professor Killoran, and she'll be more than happy to provide my information. But I do have to exit this meeting. I am due back in court in relatively 5 minutes, so I must leave, but thank you for having me today.
Thank you so much for joining us, Robert. We really appreciate you taking the time, and good luck.
And Professor Killerman and Professor Goodenough, I appreciate y'all taking the time. I could tell, like, your spirit is y'all have big hearts for this and y'all really care. So it's like, for that, to know that people like y'all exist and are working on this, it just keeps me motivated and wanting to continue to work.
I love it. I love it. Thank you.
Thanks in return. The reason that we do this kind of stuff is to support people of creativity, people with entrepreneurial spirit. That's what we're that's why we're doing it. So thank you.
Right.
And I would add, as I mentioned earlier, this is just the beginning of a chance to kind of get people's feet wet in intellectual property and how it could apply. There are other resources through the SBDC. There are other resources through our program. There's a longer video, a deeper dive on the intellectual property pieces itself. There's a lot of background. If we can be helpful, let us know how.
Excellent. Any concluding thoughts from you, Chianna? I want to make sure you got a chance to share as well.
No, I even learned a lot today. I think it's always an ongoing process. You can never get too much information. And I gather this information to take back to my family and my friends who are trying to venture into a business and start their business. And I think intellectual property needs to be at the top, when you're creating your LLC, Google the name, Google the domain, make sure it's not taken. You want to get those things done first because you don't want to run into that, oh, this is someone else's name, so it's very important to protect your brand at the beginning, even when you're considering what your business name is going to be, what phrase do you want to use, because these businesses out here they're not going to let you infringe on their rights. You can't use Apple's symbol in your business, so it's so important to research what's out there, even starting your business. So thank you for having me as a panelist.
Thank you very much for sharing with us and for your scholarship. Fantastic. And thanks, Chris, for putting your contact information in there. I appreciate that.
Thank you for the nice chats. These are very nice.
It was fun. Linda, do you have anything to take us out with?
Sure. I can't thank you enough. Boy, thank you to all the speakers. Fantastic information. I really appreciate you being so generous with your time to take time out of your busy schedules to share this experience with us. I know that not only those who are listening right now, but many, many more who are going to access the recording are going to benefit from the information. So really thank you all so very much. We really appreciate our partnership with the Vermont Law School, their faculty and students, the services available from them as one of our 9 partner organizations or spokes in the Community Navigator project. And through them, we've been introduced to incredible additional groups of people, such as this group today. So on this screen, you'll see really for general business questions, the SBDC at vtspdc.org is a great place for you to send a question, and then we'll get it to the right source, as well as the contact information for specifically the Vermont Law School and their services under this grant-funded project. So the last thing I would say is, again, everyone who registered for today's program is going to get a follow-up email with a link to the recording and the slide deck, so you can have access to that beyond today. So again, thank you so much, and have a great day, everyone.